Laurel Evans. I'm a program planning lawyer with the Law Society's Continuing Education Department, and I'd like to welcome you to this morning's program, Going for Brokers. I'd like to begin by thanking today's faculty, most of whom are visibly present here this morning, for taking the time and the effort which they put into their presentations to you this morning, and particularly for the materials which are in your binders. CLE is a non-profit arm of the Law Society, and it relies upon the voluntary efforts of faculty like today's for the presentation of all its programming. There's some administrative matters I'm supposed to deal with in terms of it's a non-smoking facility, so if you'd like to smoke, you should do so outside the east doors through which you entered. If you'd like to find the washrooms or the public telephones or the message center, please just check at the registration desk. There's someone manning it all day, and they can assist you to direct you there. And the only other point I'd like to make is that inside your gray binders, you'll find a gray evaluation sheet, which we'd ask you to take the time to complete before you leave today or fax in afterwards. We rely upon those evaluations for assessing the quality of our current programming and also for developing our future programs. So please do take the time to fill it out. I'd now like to take a moment to introduce the chair of this morning's program, Lisa Silcox. Lisa is a sole practitioner in the High Park area, where she counts a number of real estate brokers as her clients. From 1990 to 96, she was with Holden Day Wilson, where her practice encompassed a number of areas of the law with the emphasis on real estate and litigation. For over 2 years, Lisa was in-house counsel for Royal LePage Limited and Royal LePage Real Estate Services Limited. So without further ado, I'll turn the balance of the program over to Lisa.
Good morning and welcome. I have just one administrative announcement to make, and this is basically for the faculty and for your benefit as well. If you ask any questions, you'll note that we will probably repeat them back into the microphone that you ask any of the faculty members. The reason for this is because your voices may not carry, and especially where this is being taped to be shown, we want to make sure everyone hears the questions that you're asking. So if you wonder why we're doing it, that's the reason why. Thank you for coming on such a cold morning and on Halloween morning as well. This is Going for Brokers is a program designed to assist you in basically marketing your practice towards real estate brokers, as well as giving you some insight into the area. Most of you are probably real estate practitioners. There may be a few real estate brokers here. Could I just have, by a show of hands, find out who's a lawyer here? Are there any real estate brokers here? Yes, we do have some. Welcome very much to our meeting here today. It's my pleasure to introduce as our first faculty member and speaker, Bob Aaron. Bob graduated from the University of Toronto in Osgoode Law School and was called to the Bar of Ontario in 1972. He joined the family law firm, which was founded in 1930, and is now a sole practitioner specializing in real estate and commercial law. He has done a number of lectures, and as a matter of fact, Bob was one of our faculty members back in 1993 when we had another program on advising real estate brokers and sales representatives. He's lectured on numerous occasions to lawyers and to real estate agents around the province. In 1993, he conceived and co-hosted a successful continuing legal education program, Surviving the New Practice of Real Estate. He's the founding president of the Ontario Real Estate Lawyers Association and a bencher of the Law Society of Upper Canada.
Thank you, Lisa. Okay. Back in 1989, at the height of the real estate boom, you remember what a boom was like, Royal LePage, and I'm sorry to pick on them, and I'm going to do it this morning several times, Royal LePage ran a series of what I thought was brilliant full-page newspaper ads in the Toronto Press, which caught my attention. The first one, which I thought was very powerful, is up here on the easel, and it's also on the monitors. It showed a photograph of the front of an electrical panel box. Superimposed on this huge picture was this wording: why Royal LePage paid a $3,000 electrical bill that belonged to somebody else. And the small print underneath reads as follows: No, we hadn't taken leave of our senses, and no, we weren't feeling particularly philanthropic. It's just the way we do business. Here's the case in point, it said. Not so long ago, a particular Royal LePage sales representative was responsible for selling a fourplex. The listing clearly read that there was a 100-amp electrical service in each suite. All the boxes were actually labeled that way. To everyone's dismay, the electrical service only contained a 600-amp capacity per location. Sorry, that's 60-amp capacity per location. True to the spirit of our agreement to stand by each and every Royal LePage transaction, we came up with the $3,000 needed to upgrade the service. If you're in the market to buy or sell a house, try this simple test on the agent of your choice. Then stand back. You could be in for a bit of a shock. That was the ad. You can see from the length of my printed paper that there's a huge body of case law against real estate agents and brokers. And these cases are just the interesting ones. The groundbreaking decisions are the horror stories. There's a lot more. It seems that the easiest part of an agent's profession in recent years is to get sued. Anybody can sell houses. That takes skill. Getting sued doesn't take any skill at all. The responsibilities and obligations of agents have widened and become increasingly complex, and the pace of this trend seems to be accelerating, especially since I wrote and presented an earlier version of this paper in 1993. I thought the update would be easy. There was more work on the update than on the original paper. The opportunities for breaching one or more of the agent's varied duties are never ending. While this may be good news for the litigation bar, it's having a significant impact on the realtor industry as more and more real estate professionals find themselves spending time in courtrooms. And as you'll hear later this morning from our excellent lineup of speakers, the industry is constantly attempting to adapt by introducing new concepts such as dual agency, buyer brokerage, and pushing new disclosure requirements. The case in the 1989 newspaper ad was just a warm-up for Royal LePage and its insurers. Here is a fictitious ad I prepared for Royal LePage based on a reported 1995 decision in the case of Sampson and Lockwood, which is referred to somewhere in my paper. I'm sorry to pick on Royal LePage, but it was just too tempting. I'm offering my advertising copy to Royal LePage for free, but don't expect to see it in print anytime soon. Okay, here's the ad. It's not here, but I want you to visualize a photograph of an empty lot. Superimposed over this empty lot are architect's plans for a new building. And the text in my fictitious ad reads as follows. Why Royal LePage paid more than $700,000 for a mistake that wasn't our fault. No, we hadn't taken leave of our senses, and our insurers weren't feeling particularly philanthropic. It's just the way Madam Justice Kitely tells us to do business. Here's the case in point. In 1989, our agent met with officials of the Brampton Planning Department. He left that meeting with the clear impression that our client's listed property could be used to build 100 to 150,000 square feet of building space. Our agent prepared a beautiful marketing brochure saying just that, and he even forgot the disclaimer. Well, to everyone's dismay, the purchaser found out that the actual buildable square footage was 32,000 feet at most. This was our agent's innocent error. True to the spirit of our agreement to stand by each and every transaction, we and our insurers came up with the $635,000 plus 5 years interest and costs needed to put the purchasers whole again. Why, the whole thing must have cost us about $1 million. So if you're in the market to buy or sell a house or even a piece of buildable vacant land, try this simple test on the agent of your choice. Then stand back because someone could be in for $1 million shock. That's the end of my ad. So why did Royal LePage get zapped so badly in Sampson and Lockwood? The court held that the agent breached his duty to the vendor. He didn't get written confirmation from the town about the coverage. He didn't advise the vendors that his representations as their agent would be binding on them, the vendors, because they were his principals. He didn't advise the vendors that his misrepresentations could excuse the purchaser from closing. And he didn't insert a waiver or a disclaimer in the brochure. And incidentally, when the land was finally resold, there was a disclaimer in the brochure. Now, the broker, Royal LePage, was held vicariously liable for the negligence of its agent. It failed to ensure that appropriate supervision was in place for its agents, and it failed to have a policy requiring a waiver or disclaimer in its sales brochure. This, as you can see, was a very expensive lesson for Royal LePage. Here's another agent horror story, which is an important reminder of the standards that agents must adhere to. This unreported 1996 case is 669283 Ontario Limited versus Riley, and it's referred to in the paper. The judgment has not been reported because it's 100 pages long. The Rileys in this case bought a 40-unit apartment building in Kitchener in 1987 for $880,000. Remember that number, 880. They flipped it in 1988, the following year, for $1,070,000, but the transaction didn't close, mainly because the rents were illegal. The vendor's agent, who was also their property manager, knew that the building was subject to rent review orders and that the 1987 actual rents were substantially higher than the 1978 rents plus the guideline increases. In other words, the rents were highly illegal. But the agent did a financial worksheet and he didn't say anything about the illegal rents. He disclosed the actual rents rather than the legal maximum. And he took this statement and he passed it on to the purchasers. While pointing out that this passive non-disclosure that it was passive non-disclosure rather than active misleading disclosure, whatever that means, the court found that the agent knew that the illegal status of the rents was a ticking time bomb, in the words of the court, that he intended the purchasers to rely on the representations, and finally that the agent had a duty to advise the purchasers. The damages in this case, and remember that the building was purchased for $880,000, the damages after an 18-day trial were $825,000 plus interest. And this award was after the Rileys sold the building a few years later for $640,000. The agent had to pay 60% of the damages and the lawyer the remaining 40%. So it's quite obvious that the risk the agents assume may in fact be higher than the actual value of the property. So if you're advising agents or if you are an agent, beware, your damages aren't limited to the value of the property. My remarks this morning and in my written paper, I deal with the duties and obligations of real estate agents and brokers. I've tried to make my written paper a combination of the academic, touching on the basic recent case law, and the practical, giving real estate professionals practical advice on how they can meet the obligations of everyday situations. And all this so they won't wind up in a courtroom. Obviously, in the time I have, I can only touch on a few of the highlights in my 61 pages. The first three duties of a real estate agent are, in order of importance, disclose, disclose, and disclose. An agent has a duty to disclose to his principal all facts which come to his or her attention which are or may be material, and the failure to disclose these facts to the principal constitute a breach of fiduciary duty, basic law. Where there is a principal and agent relationship, the cases are clear. The agent owes the principal the obligation of full disclosure, of honesty and integrity. Over and over and over, the cases use the words honesty, loyalty, best interest of the principal, full disclosure, strictest good faith. The standards are very high. Now consider what happened when an agent deliberately concealed from his principal a very material fact in the circumstances, namely the identity of the purchaser. In the late 1950s, Joe Tannenbaum was a developer around here who was assembling land. For obvious reasons, he wanted his identity kept a secret. Tannenbaum puts in an offer for a piece of land in the name of the selling agent. It was submitted by the selling agent through the listing agent, and on its face it clearly said the agent was a nominee for an undisclosed purchaser. The vendor sees this, he accepts the offer, he closes the transaction. But when he finds out who the purchaser was, he refuses to pay the commission. He says that he wouldn't have dealt with the purchaser had he known his identity. This was the 1959 case of Selkirk and Willoughby and A.E. LePage Limited. The Supreme Court of Canada gives the agent his commission. The court said it was the agent's duty to submit the offer, and there was full disclosure of the fact that there was an anonymous principal. On receipt of the offer, the vendor had some options. He could have rejected it, he could have accepted it, Or he could have accepted it unless the purchaser was a certain person. In other words, he could have said, I'll accept it, but only if. But in this case, he accepted it unconditionally, and he could not later say that the failure to disclose the purchaser's name was a breach of duty because he never asked. This Supreme Court case is often compared with Charette versus Fitzsimmons, a 1990 decision of the Supreme Court of Ontario, where a land developer hired an agent to assist in assembling property. The agent approached a landowner named Charette and got him to sign a listing agreement. The agent did not tell him that the intended purchaser was a large land developer who was assembling land in the area. The developer bought the Charette parcel, and Charette didn't discover who the purchaser was until the day of closing. The developer had purchased neighboring properties at a higher price per acre. The vendor sues the agent alleging breach of fiduciary duty, and the court held that the listing agreement made the agent for the vendor. Remember, the purchaser had hired this guy. They had a fiduciary duty, the agents did, of disclosing all facts which they knew could affect the value of the property. Failure to disclose the identity of the purchaser amounted to a breach of fiduciary duty. The agents got no commission. And they had to pay the vendor the difference between the actual sale price and the higher price they would have got based on other sales in the area if they knew who the purchaser was. So why did the agents in Selkirk and Willoughby why did the agents win in Selkirk and Willoughby and lose in Charette? In the Tannenbaum case, the first case, the offer clearly stated that there was an undisclosed purchaser. The vendor accepts it and doesn't ask. He closes the transaction without asking his agent who the purchaser was. But in the second case, there was no disclosure at all. The agent concealed from his principal the fact that the purchaser was a developer who was assembling land in the area and that he had paid higher prices for other properties. The courts are clearly saying that the obligation to disclose is paramount and a breach of that obligation is fatal. The rule is, if you conceal material facts, you pay for it dearly. Next question is, what is a material fact? How do you determine it, and what are the tests? Example, an agent knows a purchaser's money is coming from abroad. He doesn't tell the vendor. The money never arrives, the deal dies, and the agent gets sued by the vendor for not disclosing. The Ontario Court of Appeal in this case, Howes versus Priagula, says, no, it wasn't material because the agent didn't think it was material. The test in that case was subjective, whatever the agent thought was material. What are the duties? The Court of Appeal says to act honestly, loyally, and in the best interest of the principal. So here's the Ontario Court of Appeal saying it's a subjective test. 9 years later, the British Columbia Court of Appeal says the test is objective, not subjective. There's a case called Ocean City Realty. The agent didn't get his commission because he didn't tell the vendor he was going to split his commission with the purchaser. I don't understand it, but that's what it was. The court says the agent had to make full disclosure of everything known to him which might affect his principal's judgment. The test in BC is objective. What would a reasonable person in the position of the agent consider likely to influence the behavior of the principal? Now, what are the duties of a listing agent? What are the duties of a selling agent, and who looks after the purchaser? We know the law says there's a fiduciary relationship, a bond of trust created between the vendor and the vendor and the agent when the vendor lists his property. The listing agent is relied on for his expertise in evaluation, in marketing, and the agent is often privy to confidential information such as the reasons for selling and the bottom line sale price. Problems arise, however, when the property is sold by a purchaser to another agent. When the property is sold to a purchaser by another agent, a selling agent who may never have met the vendor and who may actually act strictly for the purchasers. The Toronto Real Estate Board MLS agreement form appoints any broker member of the board as the vendor's cooperating broker, now defined to be anybody, subagents, buyer broker, or otherwise, who will be paid by the listing broker from his or her commission. It had long been the belief of various real estate boards, and it still may be, and it has been argued in more than one case, that under the typical MLS agreement, selling agents were agents of the vendor and owed them a duty of full disclosure. According to this view, a selling agent merely owed a purchaser a duty of care to exercise attention and skill in negotiating the transaction. This position was demolished in the Ontario 1990 case of Whippich versus McDowell. In that case, the vendor's residence was listed on MLS. They accepted an offer from the purchasers conditional on the purchasers arranging a new first mortgage for not less than $35,000. Nobody told the vendors that they couldn't arrange this mortgage if the purchasers did not sell 2 other properties that they owned. The mortgage condition was not fulfilled. The transaction died. The vendors sold for a lower price later and claimed that they would never have accepted that first offer if they had known that obtaining the mortgage was conditional on the sale of the purchasers' other 2 properties. The vendors sued the purchasers for breach of their obligation to use best efforts to satisfy the mortgage condition, and they also sued the selling agent and her employer for failure to make disclosure. The case went on for 4 or 5 days of trial before the vendor's case was dismissed. And listen to this comment from the judge. If Simpson then becomes the agent of the vendors, who then represents the McDowell's interest? No one. What we would have then are 2 agents working against the McDowells, the purchasers, in the interests of the vendors. And they must so work because as agents of the vendors, they owe utmost loyalty to the vendors. The McDowells are thus left to hang in the breeze. Surely this is not the law. The McDowells, the purchasers, are thus left to hang in the breeze. Surely this is not the law. It must be the case that since the McDowells retained Simpson to act on their behalf, she is their agent and no one else's. She cannot at the same time be the agent of the vendors. It would defy both law and logic if it were. Major, major pronouncement. In this case, it was found that the selling agent owed no duty of care or disclosure to the vendor. It implied, however, that there is a fundamental duty not to mislead or deceive. And I see that I'm running late, so it's amazing. You time this in advance and it doesn't completely work out. I draw to your attention the case of Notch, or K-N-O-C-H Estate versus Picken, 1991 Ontario Court of Appeal. Very interesting case, but just read it on your own. What are the duties of the selling agent to the purchaser? He or she has to be an expert. In Wong versus 407527 Ontario Limited, 1996 Ontario General Division decision, an agent drafted a week rental guarantee which was given to the purchaser by a numbered company. There was no security, no holdbacks, no personal guarantees, and you can guess that the rents fell short. The purchaser's lawyer was absolutely crucified by the court, but the agent also got dragged in and was held responsible, and this is interesting, for failing to secure a personal guarantee of the rents, or a holdback, a set-off, or a VTB mortgage. The court said that the agent was out of his depth and should have suggested the purchasers get legal advice before signing the offer. A frightening decision just came out a few weeks ago. You have to act with expertise. If you don't know what you're doing, the court says you're going to get into trouble. Okay, here's some interesting things. You have to determine what the property is, some obligations of the agent. You have to determine what the property is, exactly what's being sold and purchased. One of my favorite cases is Brumus versus Royal Trust. There were several vacant lots on a street and the agent showed the purchasers the wrong one. A year later, the purchasers were well into construction on that lot when they found out that the town owned it. Following the Headley-Byrne principle, the agent was held responsible for negligently misrepresenting the location of the lot. Fortunately, they were able to exchange lots and the agent only had to pay for the costs of the exchange. But that's frightening, and because of this, in every single real estate purchase I handle, the very first thing I show the purchaser is the survey, even in condos. Right now I'm acting for a condo owner in one of those buildings where the number on the door and the number on the plans is different. Nobody showed her the survey, and for several years she's been living in somebody else's unit. And the lawyer who acted for the builder and the purchaser, the same lawyer, says, oh, I made a mistake. It's not uncommon for agents to draft offers, in fact it's very common, requiring the vendor to provide a survey or even an up-to-date survey to be delivered within a period of time after acceptance. You've all seen those offers. A much better practice, and I think it should be compulsory, would be to attach the existing sketch or survey to the offer at the time it was submitted. And I talk in the paper about what is a survey, and the answer is it's got to have a surveyor's name on it, it's got to have a date on it, or it's not a survey. You've all seen illegible illegible fax surveys that have been photo reduced, sent through faxes 2 or 3 times, and they're totally useless. Tell your clients, tell your agents not to do it. Really practical advice. I want to highlight, now I've talked about yesterday's litigation and today's litigation. Now I want to talk about tomorrow's litigation in the few minutes I have left. There are some areas where I think agents today are not paying enough attention to their responsibilities and why I think there's going to be no shortage of litigation in the future. Here are the bear traps. Here is what I think you should tell your agent clients to do. Some really practical suggestions so they won't get sued in the future. And I want to thank my colleague Alan Dierenfeld, who's here this morning, for his suggestions in this part of the paper. Parties to the offer. Does the corporate purchaser or vendor exist? Has anybody checked? You can check it by fax. Never use in trust to describe a purchaser or vendor. These words protect no one, and there's case law to say that those words are meaningless. On estate sales, identify the parties, such as an executor or estate trustee. If the probate is not final, allow enough time for it to be final, because it takes 4 or 6 weeks to rubber stamp probate applications. If there's a spouse who has to sign, make sure they sign the offer. Is there an overseas buyer or seller? Are the powers of attorney in order? Will the overseas purchaser qualify for a mortgage here? Will he or she be available to sign? Will the deposit check come through? Identify and describe the property. Describe the property. Where is it? Don't say the right side of the street. Builder offers, this drives me nuts, describe lots as lot 54R or 54L, right or left. And I have no idea whether that means facing the lot or facing the street. So I never know which title to search, and I suppose that's risky, so I always ask the client, which is your lot, L or R? It would be much easier if builders said east or west, north or south, but not left or right. On condominiums, attach a mini copy of the plan and have the parties initial it. Circle the unit. Some condos, as I said, have different numbers on the doors than on the plans. Don't rely on assessment rolls, they're wrong. Rely on a survey, rely on a deed, and that's it. Ask the purchaser, is there a special requirement for frontage, for depth, setbacks, square footage? If so, be specific in the offer, put in an abatement clause or an increase clause. If there's a right-of-way, put it in writing. I can't tell you how many cases I found where the right-of-way wasn't disclosed and the agent picked up the tab. If the property's a link semi, say so. You can't look at a link semi and decide that it's a link semi because it's linked underground and it's not always obvious. If the parking pad is on city property, be specific. The deal's going to collapse on closing when the purchaser finds out that he's parking on city property. Describe the zoning property. If it's multi-residential in the offer, that term is meaningless. If there's parking at the rear, is there legal access? There may be access, but is it legal? Write in the things you can't see. I talked about surveys. If there's a survey, attach it to the offer. If the survey exists and the agent doesn't look at it, I think the agent is negligent. Make sure the survey is not photo-reduced or fax. If you can't read it, it's not a survey. If there's no name and date on it, it's not a survey. If the building is not shown on the land, it's useless. You can have surveys of the vacant land, it's useless. Suggest to the agents that they read the survey. Is there a right-of-way on it? Is it private or public? Is the deed, is the right-of-way deeded or possessory? Does the paper right-of-way match the right-of-way on the site? Is there a pipeline easement? Is there an encroachment onto the road allowance? It happens all the time in the City of Toronto. If you are doing a land assembly, do the pieces actually fit together? Big case in the paper where the pieces don't fit together, the assembly was useless. Deposit. Get the check certified immediately or at most within 48 hours. Advise the vendor immediately if it's NSF. Never give a check to a purchaser and say, go certify it and bring it back. Bad idea, it may not come back. The check should accompany the offer both directions on signbacks. Time limitations. What's a banking day? Some banks are open on Saturdays and holidays now. If you put in banking days in your offer, you're asking for trouble. If the offer's signed finally at 3 a.m., is that the first banking day or not? I don't know. Consider providing for a specific number of days from the last signback. And something that absolutely drives me nuts, I don't know why agents always put 11:59 p.m. as deadlines in offers. It's just absolutely beyond me. Put in 4 o'clock, 5 o'clock, 6 o'clock. But unless you want to be working at 1 or 2 in the morning, don't put midnight as a deadline. Conditions. Is a condition to arrange satisfactory financing, is that good or is it really an option? Is that what was intended? Find out what was intended and be specific. Is the offer conditional on the sale of an existing property? If so, put in a specific price, not less than or not more than, depending on which side you're acting on. Consider inserting a clause which says, if the condition fails, each party agrees to execute a release. I can't tell you how many times annoyed purchasers or vendors refuse to sign releases, and there's trouble getting the deposit back when a condition clearly fails. I'm working on one now. Put in a clause which says either that the parties agree to sign a release if the condition fails or that they are deemed to have signed a release. If there's a facts clause, put in a specific number. Draft notice clauses carefully. Consider whether they will work. Chattels. Does your client think that she will take the built-in dishwasher with her? Please be specific about chattels and fixtures. Most burglar alarm systems being installed today are on long-term leases or monitoring contracts with the installation company. Does the vendor own the burglar alarm system? How much is the buyout? And can the purchaser switch monitoring companies? Highlights, closings, GST, basement apartments, home inspection, future use, read offers, put in clauses that mean something that you understand. I don't know why we never use toxic soil clauses. There seems to be a fear of that. I have at the end of the paper a whole bunch of suggestions on how to treat buying and selling situations so that there won't be litigation. And finally, agents and lawyers can work together. Not all lawyers, as you know, are deal killers. We can help and not hinder deals, and this is one little plea that the real estate community and the lawyer community can work a little closer together with the objective of getting the deals closed. Thank you very much.
Thank you very much, Bob. It's always a pleasure when Bob speaks. And I would like to say a special thank you to Bob because in terms of the last part of his article there about the practical advice he's given in terms of drawing up the offer, it ties in very nicely with my particular part of the program, which is later on, which talks about merely the differences between the old agreements of purchase and sale and the universal agreement of purchase and sale. Bob has provided here a very nice synopsis of a number of areas that are very important. Now, our next speaker is Carl Compton, who is the director of the Marketplace Standard and Services Branch from the Ministry of Consumer and Commercial Relations. For those of you who do not know, there is going to be some very interesting impetus coming from the government to develop self-management in the real estate industry. And Carl has very kindly consented to come down here and give you some insight as to what is happening in that area.
Thank you very much. I do have slides. Elizabeth, will I be able to work with a microphone?
Yep.
Is that possible?
There's a left.
We have this one.
I don't know if I can walk around with this. Yes, please. My presentation material is somewhat different from the paper that's included in your binders. What I intend to, or I hope to accomplish, is to provide you with a definition of what self-management is, why it's a good thing, why we believe that self-management is better than government management, and I don't anticipate that that's going to be a particularly great challenge, how we intend to get there, to describe the governance structure under self-management, and to describe the residual role of government. First of all, of course, what is self-management? It is not deregulation and it is not self-regulation. It is simply the transfer of the administration of existing legislation from the hands of people who are employees of the state to the hands of employees of self-managed industry councils. The Real Estate and Business Brokers Act in the transfer does not change. It remains the exact same as it is currently. It's just, as I said earlier, the people who administer it, the people who are responsible for it, they do in fact change. Industry self-management will involve a significant migration, a migration from government control to business self-control, from a generalist bureaucracy to sector-specific industry councils where decisions are made from within. Within the current government bureaucracy, as an illustration of what I mean by a generalist bureaucracy, within the organization that contains the Office of the Registrar of REBA, is also, or are also, the responsibilities for the regulation of boxers, wrestlers, projectionists, video stores, movie chains, private bailiffs, collection agents, motor vehicle repairers, motor vehicle dealers, door-to-door salespersons, so the tin men and the people who pave your driveway and the people who sell vacuum cleaner sales door-to-door, travel agents, cemeteries, funeral directors, loan brokers, and a number of others. So you can see that within that structure, generalists are treasured at the expense of specialists. The larger decisions on funding, on resourcing, are in fact made by a bureaucracy that doesn't entirely understand the nature of the business is regulated, and in fact, under self-management, those kinds of significant decisions move from the bureaucracy into an industry that will obviously understand and make the decisions in accordance with the benefits of the practitioners and the consumers that they serve. It will move from indirect funding to direct funding, from an overemphasis on the part of government on paper processing to an emphasis on standings, compliance, from taxpayer as paymaster to industry as paymaster, and finally from government micromanagement of issues to a world where the government in fact only sets principles. And what are those principles? Equality of participants. In fact, all segments of a particular sector must have access to the decision-making process in self-management. There must be recognized benefits to all participants, including would-be participants. Self-management will not, cannot result in the creation of closed shops where newcomers to the marketplace find that there are barriers set in their way. So there will be, as I say, equality and recognized benefits to all participants. Accountability. Self-managed industry councils must be accountable for their actions and those of its members. And of course, it must be self-funding. The anticipated benefits of self-management. We would anticipate a maximization of industry knowledge and experience, including increased professionalism of the participants, enhanced consumer protection, because it's our anticipation that there will be much greater vigilance in ensuring that the rogues in the marketplace are in fact excluded from doing business. Revenues will be reinvested in improving marketplace standards because we anticipate self-managed organizations will be far more efficient than government. The registration revenues can be reinvested then in program development, enhanced inspection, consumer education programs, and in fact education programs for the participants themselves. The strategic goals. The industry will in fact lead in standard setting. It will lead in ensuring a fair, level playing field for honest businesses. It will develop rules that are set by the people who have to live by them. And it will link the fees that are paid by the practitioners to the kinds of services and the quality of services that are provided by the Industry Council. And we would also anticipate that costly litigation should be replaced with alternative dispute and complaint resolution. And why is it that we're looking at self-management at this particular point? In fact, the Common Sense Revolution set the stage for this kind of an initiative, where in fact this kind of a statement suddenly makes sense. A competitive economy demands flexible management strategies which do not impede business. In other words, we're talking about less in-your-face government and greater industry or empowerment rather. Self-management is already, in our view, a proven winner. Alone in the Ministry of Consumer and Commercial Relations, we have a relationship with a number of self-managed sectors: the Ontario New Home Warranty Program, the Board of Funeral Services, Canadian Motor Vehicle Arbitration Plan, and more recently, the Travel Industry Compensation Fund Board of Directors was elected entirely from the industry through an industry-led process, replacing the traditional process where all of the members of the board were appointed by government. That happened some 6 months ago and has proven to be remarkably successful, and was in effect meant by our former Minister Norm Sterling to be somewhat of a challenge to the industry to determine whether or not the travel industry was ready for self-management. And as I say, it's proven to be a remarkably successful pilot. Before handing over the reins for administering various acts, there is an industry readiness test. The government at this point is recommending self-management agreements be negotiated for the real estate, the travel, the cemeteries, and motor vehicle dealer sectors, all of which demonstrate already a basic level of readiness against a number of criteria: positive track record of consulting, working in partnership, and solving marketplace problems, existence of a representative national or provincial industry group or associations, and certainly in the real estate industry we have the Ontario Real Estate Association, with some 80% of registrants as members of that association, demonstrated capacity to perform some legislated functions, and professional development programs, including codes of ethics, continuing education, public information programs. And again, in that particular area, if we look at the Ontario Real Estate Association, it has long been charged with responsibility for curriculum development and the delivery of educational programs for people in the real estate industry. Bit of a thumbnail sketch of the real estate industry. Under the Real Estate and Business Brokers Act, there are some approximately 51,000 registrants who pay fees that range from $175 to $275 for a biannual period. As I mentioned earlier, there is the Ontario Real Estate Association, which represents about 80% of that registrant population. And forgive the typo, it's not $1 million of real estate transactions. It is 1 million real estate transactions annually that represent approximately $150 billion in value. Ministry enforcement activity, we receive about 600 complaints annually. There are about 150 inspections that are generated. In combination of those 600 complaints and 150 inspections, it results in a couple of dozen investigations, and from those couple of dozen investigations, we end up with a handful of prosecutions and about 20 license revocations. So from that fundamental universe of 52,000 registrants and 1 million real estate transactions, $150 billion in value overall, at the end of it, there are 1 to 5 prosecutions and 20 license revocations. Clearly, at least in our view, that's evidence of an industry that is ready for self-management and is already capable and enjoys a very professional population base. The steps to industry self-management, I'm sorry, that's not terribly readable. The steps, the introduction of legislation, the development of an agreement, incorporation of industry councils, delegation to those councils, and finally the council takes over and operates. We're already well along this particular process. The Safety and Consumer Statutes Administration Act was introduced in May of this year and in fact received third reading a month later, some 6 weeks later. The Safety and Consumer Statutes Administration Act allows the Minister of Consumer and Commercial Relations to delegate the authority for some 11 different acts to designated industries. The delegation is done through regulation under that act. The act sets very basic delegation rules, and it allows as well for the minister to appoint a minority position on that board of non-industry representatives. As I mentioned earlier, however, the industry-specific acts and regulations do not change. They continue in force. Revisions to the act or the regulation still requires ministry approval. The act also sets out the need for an administrative agreement to be negotiated with each of the self-managed industries. The administrative agreement is in fact the instrument that sets out the terms and conditions of the delegation, specifies the powers under each act delegated, the composition of the board, the financial terms of the transfer, resources, access to government assets and records, and of course the requirement to meet the ministry's current vision, which is the principle of a fair, safe, and informed marketplace. It also sets out terms for liability and insurance. Industry councils will be incorporated as nonprofit organizations. The existence of the council is a prerequisite for delegation, and as a matter of fact, a regulation would be promulgated under the Act that recognizes that particular industry council. And I think a particularly important point to make, it is these councils are separate and distinct from existing industry associations. OREA, TREB, they are not, nor will they become industry councils. We're talking about building an organization from the bottom up. It'll be an entirely new organization. The Industry Council or Administrative Authority will take over responsibility for the delegation of the Act in stages, and the staging of the transition will be tailored in a manner to meet the capacity of the industry to accept that delegation. And those council activities then include the basic responsibilities set out, in fact, under each of the acts. Certification and registration of participants, register on education, discipline, enforcement, public relations, and the council is invited to become a regulatory reform advisor to the ministry. Being charged with responsibility for administration of the act, it is also invited then to bring forward to the ministry its views on regulatory and legislative reform. The Ministry of the Government continues to approve regulatory changes, reviews the annual reports of the Administrative Authority, and will refer issues to the Council for its resolution and for its recommendations. The Administrative Authority itself, so each self-managed industry will establish an administrative authority which will be responsible for performing the delegated functions. They will be not-for-profit corporations with their own boards of directors, their own CEOs to manage operational affairs. And they will be, as I mentioned earlier, independent of both government and industry trade associations. Returning to the not-for-profit corporations with their own boards, the boards, both the founding boards of these corporations and the ongoing boards, will be selected through a democratic process that would be accessible to all practitioners. As I mentioned earlier, the industry members would be augmented by a number of ministers' appointments that would represent consumer and government interests. But in no case is that more than a minority position. The functions of the Administrative Authority, again, mimicking the Act, the registration of industry members, the denial or revocation or suspension of registration, administration of certification or qualification courses and entry exams. In many instances, by the way, although the Industry Council is charged with responsibility for these activities, it may choose to delegate an agent on its behalf. Would also be responsible for inspections, investigations, prosecutions, and we anticipate that its investigators would have the full suite of powers that currently are held by ministry investigators. Finally, management of consumer compensation funds or other consumer protection schemes, and consumer complaint handling and dispute resolution. So delivery of these functions shifts from government to the administrative authorities. The current regulatory framework remains in place. The registrar in each industry, currently an employee of the ministry, but a statutory appointment at the moment, will move from being an appointment by the Lieutenant Governor and Council to an appointment by the Industry Council or its board, and it will report to that board on a day-to-day basis. Having said that, the registrar will retain the autonomy that he in this case, currently enjoys to make day-to-day decisions on registration matters. Those registration matters are not, in fact, governed by the Council. The Council will set overall policy guidelines in which the registrar makes those day-to-day decisions. The accountability mechanisms for the administrative authority. The administrative authority is required by the Act to deposit business plans and annual reports with the minister, and the administrative agreement will set out the details to be contained in each of those plans. The business plan will include performance measures and service standards, and the annual report will provide the report of the administrative authority as to its success in delivering its commitments, and that annual report is tabled in the legislature by the minister. As well, it would be audit reports, the ones required through corporate law. The government's role in this: the government now refocuses from paper processing, removing paper from in trays to out trays, from data entry to legislative, policy, and regulatory reform. It does, however, retain authority over industry-specific legislation and regulations. Such things as qualification standards for entry, mandatory security arrangements, marketplace standards for behavior. The Minister of Consumer and Commercial Relations, after all, does, as an elected representative, a member of Cabinet, he is still responsible for the administration of the Act and needs to answer questions in the House when things go awry, and so continues to maintain a certain minimum level of authority over the Act and the activities of the administrative authority. But the emphasis, it really is on minimum. My final few slides somewhat recap earlier comments and setting out the residual role of government versus the role of the administrative authorities, moving from right to left, or now is that east to west? Develop business plan outlining objectives, planned initiatives, performance measures, developing and delivering an annual report, providing additional reports as required, and advising the minister of emerging critical issues. There will have to be some political savvy, obviously, left within the administrative authority to be able to recognize those things that may arise in the House, and the minister will have to be advised accordingly. The ministry, in its view, or minister, reviews the business plan, reviews and tables the annual report in the legislature, may require ad hoc reports, and reviews the administrative authority's communications and issues management strategies. Sector-specific legislation and regulations. Ministry still establishes and maintains responsibility for amending legislation, regulations, and delegates powers to the administrative authority. The administrative authority, in its turn, delivers those delegated responsibilities and, as I mentioned earlier, is invited to bring to the minister's attention its views on regulatory and legislative reform. The governance of industry organizations. The minister will review the terms and conditions for board composition and selection process to ensure that, in fact, the process does allow for a democratic process that is accessible for all segments of the sector. And the minister maintains the right to appoint a minority of board members that will represent the consumer interest. The industry association or administrative authority, in its turn, establishes industry's organization structures, salary levels, staffing, and also has control over the fees that it charges registrants. And finally, the board will oversee the industry body, including passing and amending bylaws. And the final slide, industry standards and codes of conduct. Again, ministry maintains the right to amend or repeal regulations or adjust marketplace rules, and will continue to conduct intergovernmental negotiations on trade agreements, etc. And the administrative authority has a corresponding and complementary series of responsibilities. That, I think, was about a 17 or 18 minute walk through self-management, and if there are any questions, be pleased to attempt to answer them.
One comment on the statistics. You say on the number of transactions annually in Ontario. And I think you may run into actually zero. I know the Congress was maybe 50,000 transactions this year, and it's been a good year. And that represents about half of the businesses. I think you find that the number of transactions that realtors are involved in annually would be between 120 and 140,000, not 1 million.
Would you repeat the question into the microphone?
There's some question as to whether or not the number of transactions on an annual basis is in fact 1 million or more like 100,000. Actually, that's we've received that question in the past, and in fact, it's based on the statistics that we gather from our registry offices across the province.
It's interesting because I run a real estate board, as I say, and I've been a member of that for 14 years and been involved in this the 50,000 transactions will be a very good year this year. As I say, we represent half of the transactions.
A considerable amount of the transactions,
It's
yes.
interesting to see, try to figure out where you would get 1 million versus, say, about 120,000. Where that other 180,000.
Yeah, as I say, it's derived from the collection of statistics provided by the 55 land registry offices across the province.
I have another comment. At present, complaints against agents and brokers, the results of those complaints are never disclosed to the complainant, unlike complaints against lawyers and law societies. One would hope that when you defer this to the industry will be compelled to advise complainants of the results of their investigations. That's not happening right now.
Absolutely, and in fact, I think you're looking at the current operations of an industry association, and this will be very different in that it will publish an annual report, and as a matter of fact, the annual general meeting has to be open. So it's our anticipation that all of its activities, in particular the kinds that you're talking about, would be open and accessible and published.
Is it feasible that the real estate,
Okay, yes, sorry.
is it feasible that the Real Estate and Business Brokers Act, when it's handed over to this new body, will be divided into two licenses? We have a real estate license and a business broker's license with separate educational requirements.
I think, in fact, that's certainly a possibility, but it would be a decision that would be taken by the new Real Estate Council of Ontario. It's been an issue that's been raised in the past, but we've operated with the Act in its current structure without making that distinction for decades now. And it would be our anticipation that that issue would be resolved by the new Real Estate Council. But certainly that's a potential outcome. And the question was whether or not there could be a division in the Act and in its administration between real estate practitioners and business brokers. Sorry.
So the current registrar or the director or the ministry will not be making those recommendations. It will be the responsibility of the new council or board.
It will be the yes, it will be the responsibility of the new council to make those decisions. Now, you mentioned it won't be the responsibility of the registrar. The registrar, in fact, will no longer be a ministry or government employee. The registrar will be an employee of the Real Estate Council. The only residual role of government and staffing of government will be what is effectively a contract manager to oversee the contract or the administrative agreement that will be signed between the parties. But that registrar function, the director function, moves out and becomes a responsibility of the Real Estate Council. Richard.
Could you give any indication as to the thoughts about reforming the legislation? The legislation is a little dated and doesn't have many of the features that, for example, the recent College of Teachers Act has, or the Regulated Health Professions Act has. Has there been any thought about the timing of those reforms?
Because the ministry wanted to undertake self-management agreements in a number of sectors concurrently, the decision was that rather than amend the existing legislation and attempt to get room on the busy legislative calendar for each of 11 acts, What would happen is that the 11 acts would be bundled under the Safety and Consumer Statutes Administration Act. Delegation would be handed to administrative authorities, who would then be in a position to come back with their recommendations as to regulatory reform. A greater amount of control of that review of each of the acts then would be conducted by industry councils, run by industry members, and the anticipation is the reforms would be sounder than if that regulatory reform had been conducted by the ministry. And if it was conducted by the ministry, we would probably be talking of living with the same act for the next several years.
Thank you very much, Carl. For those of you real estate practitioners, it's not until you have a real estate salesperson come to you with a problem with their licensing, where all of a sudden their livelihood is being wiped out, or they have an inspection that is being done by the government, that you realize how important these will be to the real estate industry. These changes will be in terms of the Real Estate and Business Brokers Act and this change in how things are going to be done in the real estate industry. Thank you very much, Carl. Our next speaker is Merv Burgard. He's a graduate of Osgoode Hall's Law School and carries on his practice in London. He's presently counsel to the Ontario Real Estate Association. The short form for that is OREA. And he has also has been counsel to several other real estate boards in Ontario. For you, those of you who perhaps do not know, each of the there's a number of different real estate boards across the province which govern their local areas. He is currently the author of the OREA Real Property Law textbook and several of their professional seminars. He's currently involved in the self-management initiative for the real estate profession.
Thank you very much, Lisa. Ladies and gentlemen, good morning. You will have before you, again, as in the first case, a paper. I do not propose to go through and read that paper to you, but rather to highlight some of the points of it, and more importantly, to finish at the appropriate time. I notice that I finish when you have coffee, so you have a great urge for me to stop talking pretty soon. I will do that. The beginning parts of the paper, if I can just go through the headings and the appendix, what I have tried to do is to put together not legal stuff so much as a very practical approach to what the realtors have. The headings are a brief modern history, the CREA, Canadian Real Estate Association Code of Ethics, Standards of Business Practice, which is then adopted by all of the boards throughout Canada. Various then paper trails from brochures to listings and offers, which we'll talk about in a few minutes, and running through then to internal office policies by the real estate firm itself. The appendix then has put together those documents in the event that you're not familiar with all of them or some of them because they're quite new. As you've already heard from Bob Aaron earlier, there is and remains to this day confusion within the public and within the real estate professional as to who's representing whom. Normally that's not a problem for you and me as lawyers, because when the client comes in, we're pretty much aware who we're acting for and who we owe our duties to. That may not be the case in the real estate business. A number of studies were run asking a typical buyer at the end of a transaction who their, in quotes, agent was, and they always pointed to someone. In fact, as you've heard, the law and or the board rules and regs assumed something quite different. So we had a bunch of assumptions that were being made that may have been true in the 1940s or 50s and are not true in the 90s. And in the first part of my paper then I talk about that confusion. To try to deal with that confusion, the real estate boards and associations met, and CREA, that Canadian umbrella group, passed rules in their code of ethics dealing with disclosure. There was to be a voluntary disclosure about the agency relationships. That was then enhanced by written disclosures, January 1st, 1995. And again, that background is in previous papers put on by this organization in earlier seminars. At the back of the materials, and again, not to look at them now, but at the back of the materials are two types of disclosure forms that are generally in use in this area. The OREA disclosure brochure and the Toronto Real Estate Board disclosure brochure are slightly different. There's nothing magic about them. Later on in the paper, you will see that some of the challenges were to deal with some of the practical problems that are shown on this overhead, and again, this is in your material. The basic multiple listing, MLS, rules and procedures that each board determines will govern itself had to be rewritten. Some of them assumed that the selling broker was a subagent, in quotes. They have all been rewritten to make them more agency neutral so that people can do what they want. The typical definitions then that flow from that, you'll be looking at a cooperating broker. A cooperating broker may mean the selling office, a subagent in law. It may mean a buyer's agent acting for the buyer. And then, like any good lawyer who prepared that, the lawyer who did it said, or otherwise. A subagent, a buyer's agent, or otherwise. And I have no idea what or otherwise means. That will depend on your creativity in developing some new role for them. And acknowledging the difference between cooperating with each other and who actually pays money. A great discussion within the community got to be if in fact the person who pays the check, does that establish the relationship and the fiduciary duty? The CREA Code of Ethics and Standards of Business Practice was looked at and is being redone. And again, forms were done, including such things as the listing form, the agreement of purchase and sale. And as you'll hear from Lisa later on, that has now become in Ontario the Universal Agreement of Purchase and Sale. The Toronto Real Estate Board historically had a different one, and in courses in the bar admission course, there was always a difficulty of, do you teach the Toronto form or do you teach the everybody else in the world form? The Toronto Real Estate Board has now adopted the OREA standard forms. All of these forms, and a number of them, will then be used throughout the province. It should make your life simpler and the realtor's life simpler. Confirmation of cooperation was to be a document then, since it was to be generic and neutral, then we better figure out who's who in this game so the realtors could talk to each other and confirm the relationships and the representation. A buyer agency agreement was then prepared, also called a purchaser agency agreement. The American language tends to be drifting up from California to British Columbia and hence to Ontario, and again trying to make some of the forms national in scope. They're generally using those words interchangeably, purchaser and buyer. And the real bugbear within anything is the relationship if in fact the firm is acting for both the buyer and the seller, this dual agency role. And whatever happens then, to encourage a revised policy manual for each agency. Since the policy manuals were designed for vendor agency with unrepresented buyers, as soon as you go into any other relationship, obviously they need different roles. Those matters were discussed through OREA and its various boards, as you will note in my paper, and they have seminar materials, some of which I assisted in preparing for them, on agency matters and agency decisions, noted in your material. This year, a couple of pages over, there is a new one called Agency Practices. And my paper that I've given to you today is in fact a summary and highlighting some parts of that seminar material. As I indicated, if you'll go down to the CREA Code of Ethics and Standards of Business Practice, Article 3 of that standards sets out what the disclosure should be, that the realtor shall fully disclose in writing. Just stopping there, as Carl mentioned in his topic, a realtor is a person who belongs to this organized real estate group. That is about 80% of the registrant base. So 20% of the practitioners in this province are not required to follow these rules. A new council may say, no, all of these rules are going to be consistent through every registrant, not just voluntarily adopted by organizations such as OREA. As I've indicated, there are then, number 3 in your topic, agency disclosure brochures, and those are found at the back in tab A and B1. The key to those, obviously, is that the person handing them out understand what they say and then explain them carefully to the consumer, who will acknowledge receiving them and understanding them. What will then follow, obviously, is the next document in the paper trail. If I'm a vendor, that would logically be the listing. If I'm a purchaser, that would be a buyer agency agreement, if I chose to hire that realtor or that real estate person. Obviously, I may choose not to do so in either case. I may be an unrepresented vendor. Typically, real estate people call them FSBOs, for sale by owners, or I may be an unrepresented buyer. Realtors and real estate people generally call them customers rather than clients. The nomenclature is significant from a practical one as well as from a legal one. And as you've heard, there are the 4 Ds: decide, disclose, document, and then do it. Your problem will be acting for brokerage firms is to assist them in the decision of what the relationship is that they want to have with their client base. The normal grouping is set out of a single vendor agency, and if I can call that the traditional real estate firm, what it was in the 50s. There are as well some single purchaser agencies in operation both in Metro Toronto, Hamilton, and a few other isolated situations. They tend to be very large in the United States and pretty small here in Ontario yet. Dual agency in-house is typically what will happen then if the agency is representing both the buyer and the seller. That will happen in our practice if somebody in our firm is acting for the vendor to close a transaction and somebody else in the firm acting for a buyer in that same transaction. The difficulty of trying to build firewalls is obviously of great legal significance. The rest of these in theory can happen. Dual agency, outhouse, pardon my language, but it was the only one I could think of other than in-house. Then there's another magic one called limited dual agency in-house, and I'll talk about that a little bit, and outhouse. Single agency in-house, dual agency outhouse usually doesn't work. Single agency or in either, but never dual agency. Those are the typical options that a firm may be looking at and then trying to decide which ones to follow. The normal relationships, as I've said, have been a vendor relationship only. That one is item 6 in the material, called single vendor agency. Even in that one, there could be conflicts of interest. And just to set up one simple situation, if you were a builder going to hire a real estate firm, would you like them to also act for other builders? Or would you like them to be faithful to your product? Is there a potential conflict of interest in acting for 2 people who happen to own condominium units in the same building? And just posing the question will lead it to you. The Privy Council dealt with it in Kelly and Cooper in 1993. That matter went all the way to the Privy Council from Bermuda only because the purchaser seemed to have enough money. His name was Ross Perot. So that you may find that some of these clients and or customers are more knowledgeable than the typical lawyer and or real estate person. The listing then, the Ontario Real Estate Association listing, then decided that it would add into the listing contract itself an acknowledgement of that potential conflict. I acknowledge that you may be listing other properties that may be similar to my property, and you may market them. An acknowledgement of that conflict situation. That listing agreement is found at tab C in Clause 7 of my paper, this clause is referred to. This clause does not appear in the TREB form. Single purchaser agency is quite obviously, from a legalistic point of view, vendor agency turned upside down. The same principles are going to apply. Nothing magic changes. Do a seek and find, change seller to buyer, and write a new law text. The agency principles should be the same. However, you will see that in that situation, the conflict becomes even more apparent if you have two buyers who are both looking at the same property, and your firm is representing both of those buyers. So if I had two sellers, is there a conflict? If I have two buyers, there is clearly a conflict. In fact, Professor Foster, noted in Clause 9 of my paper, talks about it being highly questionable whether or not that could happen unless, again, there is a disclosure and an acknowledgement. That is done in the buyer agency contract from OREA, again with a clause indicating an acknowledgement and a consent. That is in the bottom part of Part 9 of my paper. Again, just acknowledging that there may be two people interested in the same property, and representation can happen without a conflict of interest. Just stopping there, even so, somebody's going to have to decide how you're going to practically deal with that conflict. And I'll mention that in my concluding remarks, that in the policy manual, operations manual, we'd better make some clear distinctions about, does one person go first? Do they both go together? How practically is this thing going to be marketed? And what are the legal consequences of doing that? As lawyers for those brokerage firms, you should be expected to be able to answer and assist them in making some of those legal decisions. They're marketing decisions from their side, they're very legal ones from yours.
Just on that point, isn't there also a conflict as to what information the government is
Absolutely. And the question will come up as we go through this, what is the relationship then about the confidentiality of any information and or the process? And does that person understand that this may happen? The first purchaser who expressed an interest would negotiate it without any competition from the second one, or both purchasers could compete at the same time, or both purchasers would be told all of the details, or neither purchaser would be told the details, or should both people have separate real estate people representing them, even if both of them are my, quote, client, unquote, I'm the salesperson? Or should the broker be present for the presentation of competing offers? If in fact you've got two salespeople acting for two buyers, should the broker be the mediator or somebody else? If you suggest that to brokers in the firm, they may go, at 11:59 p.m. I'm supposed to be where? And that'll go back to our 4 or 5 or 6 o'clock discussion earlier. Any number of combinations of those things then are possible as long as the clients understand them and acknowledge them up front. And it will be your role to assist the realtor in drafting that and making sure that it's understood by everyone. Number 11 talks about disclosing, as you've already heard from the earlier paper, and I will not beat on that one. The documentation then, as I've mentioned, deals with the listing contracts and other ones. The 13 deals with a form found now in tab G of your paper called a Confirmation of Cooperation and Representation form. Confirmation of Cooperation and Representation. Both parties in a normal transaction then, having been given a brochure up front which says possibly this what may happen, during the process should be given some documentation which confirms what in fact is happening. And there were 2 forms that OREA developed. They've been compressed into one. It's easy to remember. It's Confirmation of Cooperation and Representation, CCR, as in MCCR. That one's at tab G. I would ask that you look through that. At the end of number 13 in my paper, you will see that TREB uses a somewhat different form called an agreement to cooperate form, and that's found at tab G2. There used to be some place in the typical offer where agents were referred to. You'll recall that at the top of the offer form, it said, purchaser agrees to buy through blank vendor through agent. And then it had listing agent and selling agent typically up there. A great discussion comes up about whether or not any third parties and relationships about them should be in a contract between a buyer and a seller. For any number of reasons, that was deleted, and Lisa will be highlighting some of that in her paper when she goes through the universal agreement of purchase and sale. I would simply point out that that information is no longer there, that in fact finds itself someplace else. And that is going to be found in the bottom of the offer at the end of the agreement of purchase and sale. Again, the agreement itself is found at tab H in your material. The rest of the agency kind of relationships and everything else is at the bottom. Part 15 of the paper talks very quickly and in a frightening way about the most difficult concept that real estate people and lawyers are dealing with now, called dual agency. If, as you picked up, I had a problem with acting and disclosing things to those two potential buyers, what are we going to disclose to the buyer and the seller if we're acting for both of them in that same firm? And the earlier discussions about the identity of people or whatever else become rather moot. The dual agency brochure, in that brochure that's handed out at the beginning, dual agency says very simple, nothing is confidential. Tell everybody everything, as you and I would in our practices. In my paper, I have focused on some of the difficulties with that. In the second paragraph, in clause 15, real estate practitioners have been warned that undisclosed dual agency must be avoided in all circumstances, and that disclosed dual agency is a dangerous practice. There follows some comments from various papers and cases dealing with that difficulty. And those will have to be resolved somehow in paragraph 15 of the paper with various kinds of cases. And these may be the questions that will come up as a practical matter that you may be asked to assist in resolving. What is confidential in a dual agency? And the first answer is nothing. Then how do we get around the conundrum of, if somebody asks both lawyers in a law firm to act for them, should they do so? How can that client get independent legal advice about the wisdom or lack of it in having one firm represent them both? The ILA problem that you and I deal with is even larger, I think, in the real estate business. Can an interested party advise two potential clients of the risks in entering into that relationship? How can you do it? How clear should the disclosure be? In fact, the cases will say that the onus is on the dual agent to prove that that person would have taken on that role, and allowing whoever it is, the professional, lawyers or client or real estate people, to act in that capacity. The onus shifts on you to prove that, which can be very difficult, obviously. In that situation, who's going to get the, quote, best deal? Does the agency just become a middleman, some mediator, or do they still maintain that strong role that they had earlier as a negotiator? Then, as I mentioned, you could have something then in 16 called limited dual agency. Limited dual agency is whatever you want it to mean. And you will get very creative then in drafting this. Everything is confidential is the way we started off in a vendor agency. Nothing is confidential in a dual agency. The limited dual agency tries to do this. Well, some of these things are confidential, and some of these things aren't. Should identity be a confidential matter, yes or no? Should the purchaser's requirements, should the vendor's motivation for selling be confidential, yes or no? And you will see in the paper in item 16 that in various jurisdictions like British Columbia, they have scheduled out very simplistic things like that. The paper ends with an office policy process, and what I've done is highlight the 3 typical policies: vendor only, buyer only, and dual agency, and that the firm will then be required to organize an office policy depending on its decision. I have then summarized for you some of the things that might go in a broad outline in those office policy manuals in 18, 19, and 20. The process is also set out in the paper as a practical one, as indeed is a copy of the TREB agency disclosure process, of how it follows and how it flows and what the forms will look like. Again, at your convenience and at your time, go through that. It is significant, I will end as Bob did, it is significant that this whole process will work intelligently only if the lawyers and the realtors do that in a partnership basis and a very cooperative basis. At the end of the session, I'll be pleased to answer any questions you have, but it is now 10:40. Thank you very much.
Thank you, Merv. Now is our coffee break. We'll start back here at 11 o'clock.